So today we're going to be talking about Florida administrative complaints. Specifically, what even is a complaint and what do they look like, why you got one, and what your options are if you receive one. An administrative complaint is something that the Florida Department of Health will issue against a licensee. So whether you are a licensed doctor or nurse or any type of healthcare provider, if you have been under investigation and there is evidence that you committed a Practice Act violation, then you'll receive this administrative complaint. That's exactly what it's going to say too, administrative complaint. It'll be served to you at the address that is listed under your license, and it'll provide you with an indication of what actions or what you failed to do, for example, which constitutes a Practice Act violation. It'll also list the particular statutes that you are alleged to have violated, and it'll provide you with instructions as what your options are. This can be kind of hard for a layperson to understand, but at the end of the complaint, there'll be a page called Notice of Rights. That's probably the most important page as a respondent that you need to read, because that is the notice of your rights. So what do you get to do if you get a complaint? What you need to know is that if you get a Florida administrative complaint against your license, you have 21 days to answer. You have 21 days, and that is calendar days from the moment in which you received the complaint to provide an answer to the Department of Health as to whether you plan on disputing the facts that are alleged in the complaint or whether you don't dispute the facts in the complaint. So be very careful and read them. Why are the 21 days important? Well, that's because if you fail to answer within those 21 days, then you basically waive your right to say anything in your defense. You don't want that to happen, especially because some of the allegations are very serious. If you're found culpable of these violations, your license will be disciplined, and you could be facing something as serious as revocation. And that is permanent. Short of that, maybe suspension, maybe probation, who knows? But that seriously compromises your ability to work and the value of your license. So if you get the complaint, the first thing you'll need to note is that it's usually provided via certified mail. The Department of Health will look at the actual tracking number to identify when the complaint was specifically served to you and will count 21 days from that date. It's calendar days. Weekends count. Holidays count. Don't mess around. Let's say that the complaint alleges a whole bunch of facts and, you disagree with what the complaint says. Then you really are electing a formal hearing. That's what you're asking. You want your chance to speak, right? You want your chance to present evidence in your defense. Then you want a formal hearing. A formal hearing is basically a trial. That's your way of saying, Department of Health, I want to defend myself. I want to have my day in court. And so the department, assuming you answer within the time frame, will petition the Division of Administrative Hearings to open and initiate a case there. An administrative law judge will be assigned to your case and trial will begin. That can be daunting. You probably don't want to go to trial without an attorney. So call an attorney if that's what you're planning on doing. A formal hearing is really your only option to try to defend yourself against the allegations. If your plan or your goal is to try to get the complaint against you completely dismissed, that's the only way to go about it. You need to have an administrative law judge that will review all of the facts and make a determination as to whether or not the facts support the allegations against you. And when that judge makes that decision, it'll go back to your respective board for them to decide whether to impose a penalty. That is assuming the facts are against you. So what happens if you don't want to do a formal hearing? Well, that really means that you're electing an informal hearing. That sounds a lot less intimidating because of the word informal, but there's nothing informal about it. Don't be mistaken. What informal means is that you don't dispute anything that this complaint says. If you have no disputes, then you get to go to an informal hearing and you appear before your respective board, and the board may or may not have questions for you, but you're basically there for sentencing. It's like a guilty plea because you're not disputing anything. Don't be so lighthearted when you get this document and just let yourself be overwhelmed by the word formal hearing and then select informal. Don't do that. You want to review what the facts actually say. You want to review what the allegations are, and you want an attorney who specializes in this type of work to help you decide what your options are. In most cases, an informal hearing will result in discipline. There's really no reason for a case dismissal at that point because you're admitting to the allegations. So are these two the only options available? Well, not really. You also can settle. And most of the time, the Department of Health will provide you with a settlement agreement along with the complaint. So when you get the complaint, you're also going to get a document called settlement agreement, and it'll include basically the language that you need to abide by to settle the case. It'll have some agreement that, I don't know, you have to pay a fine, or you have to do continuing education classes, or maybe that you agree to have your license suspended for a period of time. The settlement agreement that you receive in the mail along with the complaint is just the first offer from the Department of Health, and a skilled attorney can take that and use it as a basis for negotiations to get you a better settlement. So you don't need to sign that settlement. You can try to negotiate, but there's a skill to be able to negotiate, and there's certain terms and certain violations which realistically prohibit that much flexibility. A prosecutor might not be so inclined to give you a lenient settlement if, say, you're accused of healthcare fraud, for example. You want to make sure that you contact an attorney because the strategy behind what to do when you receive a complaint is complicated. It spans the time before you even got the complaint. In fact, we talked about Department of Health investigations in another video. I suggest that you go and look at that too. But knowing what the investigation was based off of and what the investigative file contains will be crucial in determining what is the best strategy. The other thing to consider is that if you want to go to a formal hearing, that might be very expensive. People don't realize, but you're on the hook for the department's costs. What that means is if you settle or do an informal hearing or go to a formal hearing and you lose, the department's cost for investigating your case and then prosecuting you lies on you. You got to pay that back. The cost for somebody who elected an informal hearing are going to be lower than somebody who elected to go to a formal hearing at the Division of Administrative Hearings. That's because the department had to spend more money to go to trial against you. So if you want to go to trial, you want to make sure that you're doing that and you have a good chance of winning. It might not be cost effective otherwise. Main things to remember is when you get that complaint, you have 21 calendar days from the time you receive it to provide an answer. You have two options, whether to dispute the allegations or not dispute, with the understanding that if you don't dispute the allegations, you're basically admitting to them, and you may have a settlement. But that all depends on your ability to negotiate, and again, maybe you want to do that with an attorney. So if you liked this video, go ahead and click like, and if you didn't like it, it's okay. You can dislike it. If you have a comment, leave a comment below. We do read those, and we can get back to you, and we'll get back to you. You also can reach us at our website. We take consultations all the time if you have a question. So please go ahead and reach out to us if you want to. Subscribe to our channel and look out for new content. Thank you.